Well, as you may see from our first slide, our unit organized the first two seminars on the EOPP and ESCP, respectively, on December 4th, 2020, and on February 26th, 2021. And both events were held on the digital platforms Zoom and Teams due to the pandemic restrictions existent at that time. Speakers at these events included both members of the unit in Trieste and also external experts selected for their knowledge and experience in this field. The events were organized in coordination with the bars of the 4 cities of the region and with the Center for Judicial Lifelong Education in Trieste. The event on the EOPP was attended by roughly 350 people, while the event on the SCP by roughly 100 people. Attendees included lawyers, judges, university professors, students in law and in political science, as well as legal translators. Further, in collaboration with the Uppsala team, we co-organized actually 2 other events in person, 2 seminars on both, again, the EOPP and the SCP. The first seminar was held this year in the beautiful Faculty of Law of the Uppsala University on October 8th and 9th, 2021. And the speakers here were Sara Tonolo, Marta Infantino, Giuseppe Pascale, and myself. Roughly 10 people participated. The second seminar was held in the Faculty of Political Science at the University of Trieste on November 26th and 27th. And the speakers here were Eric Bylander, Mary Linton, Natalie Tornius, who are here today also, Friedrich Sioval, and Samuel Rudval. Here, roughly 50 people participated. The lively discussion during these events and the positive rate of approval in the feedback forms filled out after the events confirmed that participants highly enjoyed them. All the events, of course, were recorded, and this recording is available on YouTube or will be soon available there. Now, let's sum up some results from the above initiatives, webinars and seminars. I will first focus on the results and comments regarding the EOPP, while my colleague Marta Infantino will then focus on the results pertaining to the ESCP. Well, staying with the EOPP, sorry, I took the wrong slide. We find out both in research and in discussion among speakers and participants to these events that the awareness of the availability of the EOPP and the actual rate of recourse to it on the Italian territory has always been and still is very low. Why is it so? Well, first of all, we can focus on a few structural factors embedded in the EOPP regulation that might have influenced its little success. These are, for instance, the optional character of the procedure, or the limitation of its scope to cross-border claims, or the linguistic and legal diversity existing across the EU that cannot be overcome with this instrument only, or the limited digitalization and coordination of civil justice services across the EU. Next, one should note that on the one hand, the EOPP regulation conveys rules that are considerably distant from those Italian lawyers are familiar with. In fact, in Italy, the National Order for Payment procedure is a spurious procedure, also called procedure with proof. This means that documents shall be alleged to the application and the court shall operate an ex-ante control of the probability that the legal basis of the claim is valid. On the contrary, as we all know, the EOPP has been modeled on the Austrian pure procedure, that is a procedure without evidence. Here, no allegation of documents is possible. However, the applicant has to generically describe the evidence, and the court shall perform a formal control only before it decides to issue an European payment order. Well, becoming familiar with this different model of procedure in Italy is quite difficult for our lawyers and judges also. And this problem is also exacerbated by the lack of a specific national law devoted to the implementation of the EOPP regulation, and devoted then to the coordination of European procedural rules with the national rules of civil procedure. Also, we noted that very limited information about the EOPP regulation is present on national justice websites, including on the website of judicial offices. Therefore, it comes to no surprise that if there is documental evidence of the claim, most litigants in Italy prefer the national order for payment procedure certified as European enforcement title. This is a very striking and important point. On the other hand, we noted that foreign litigants and lawyers are likely wary to start a procedure in Italy in light of the country's reputation for lengthy trials and delayed justice. In the average, our trial lasts more than 3 years. Moreover, for a foreign litigant, it's very difficult to apply for an EOPP in Italy without the assistance of a lawyer. The requirement to describe the evidence set out by Article 7, litera E of the regulation, EOPP regulation, implies the debtor's knowledge about the national law of evidence of the state of origin, and this most probably requires professional legal aid. It's clear that these facts, coupled with the fact that Italian courts accept only applications written in Italian language, thereby requiring professional translation, raises notably the costs of access to this procedure. Furthermore, it must be noticed that the Italian government decided not to introduce a special rule of jurisdiction, a rule that could have been challenging application, conveying application for a European order for payment before one or before a few specialized courts. In Italy, ordinary criteria for determining jurisdiction apply also for the EOPP, making it very hard for prospective litigants to identify the competent courts and for courts to accumulate experience throughout specialization. Well, despite all these problems, the events devoted to the EOPP within this project demonstrated that in Italy, there is a lively interest in better understanding and applying this procedure. And now we go to the ESCP with the account by Marta Infantino.
Thank you very much, Francesca. So as to the ESCP in Italy, there are many observations that run parallel to those Francesca just made about the EOPP. And our project confirmed that there are many factors that are both embedded in the regulation itself and factors that are embedded in the Italian context that might explain the limited success of the ESCP regulation, both throughout Europe, but especially in Italy. And as far as the structural problems at the EU level, as already mentioned by Francesca, one problem is the optional character of the procedure that leaves claimants free to opt for the more familiar national procedure, and the limited scope of application of the ESCP regulation, which only applies to transnational claims below 5,000 euro. And then, of course, another problem is linguistic barriers, because notwithstanding that the forms are available in many languages, it remains the problem that ESCP applications in many countries are only accepted in national language. And by the way, this is exactly what happens in Italy, which only accept applications written in Italian. And furthermore, still at the European level, other barriers come from the limited digitalization of justice services in many countries. That was, for instance, the case of Italy, especially in the pre-COVID era. That is probably one of the few points where COVID actually helped to modernize this. I mean, created some kind of positive effect on the system, that it forced digitalization that was not completely achieved before. And also there are huge problems in coordinating civil justice services, for instance, in how to pay trans-border fees or how to serve documents abroad, how to get evidence from other countries, and so on and so forth. And notwithstanding the presence of many EU regulation dealing with these issues might still turn out to be extremely complicated for a claimant. But then there are also other factors that are really related to national and local context. And we will now very briefly deal with the factors that mostly matters as far as Italy is concerned. Let us start with a number. The Justice of Peace of Milan, which is the Justice of Peace, is the competent judge to hear ESCP claims in Italy. And the Justice of Peace of Milan is, of course, presumably the one who is receiving more ESCP application, considering that Milan is the financial and economic hub of the country. Well, the Justice of Peace of Milan per year receives on average from 20 to 25, let's say 25 ESCP application, which is a very low number, considering that probably this is one of the busiest Justice of the Peace throughout the entire territory. But you should also consider that Justice of the Peace offices are more than 100. So, and as these numbers that I'm giving to you makes clear, we don't have clear statistics. It's a problem similar to that in Sweden. We don't have clear statistics about how many judgments, and it's very hard to retrieve this judgment. You should go to each Justice of the Peace website and then try to find out the judgment, which for reasons very similar to those highlighted by the Uppsala teams might be a task much harder than one might imagine at first sight. Anyway, so it's for sure that there are few ESCP applications in Italy. And one reason to explain that, as already hinted by Francesca with regard to the EOPP, is that probably foreign litigants have a sort of limited willingness to start a proceeding in Italy in general, and also with regards to the two regulations we are examining right now. And here probably the country's reputation for lengthy trials and delayed justice, the Italian torpedo issue, etc. Well, that did not help really Italy to establish itself as a fashionable jurisdiction for foreigners wanting to have their claims solved by a judge. And this might explain why we have few applications from foreigners in Italy. But what is also true is that there are few applications of Italians abroad. So in the other direction. And this might be related to the fact that there is limited awareness in general in Italy about the availability of this, the ESCP procedure, and the same would apply, as Francesca said, for the EOP regulation. So that takes us back to the original question, why? I mean, why Italians do not, considering especially our reputation of lengthy justice, well, why do not Italian claimants run abroad applying for ESCP application abroad? That would make sense. But in order to answer this question, we need to consider certain features that are structural to the Italian context. And one first thing to be highlighted for the ESP, which is very similar to what Francesca said for the EOP, is that the ESCP regulation inserted in the body of the Italian civil procedure a device that was totally unknown to Italian claimants and litigants, insofar as Italy never had a small claim tracks before the ESCP regulation. Like, for instance, in Sweden, they mentioned, if I understood it correctly, that before a national claims track. And so I guess that makes it easier to understand what the ESCP regulation is about. And then still, even a Swedish lawyer would prefer the national one vis-a-vis the European, but at least it was easier for them to understand what it was. For Italians, it was something totally out of the civil procedure framework, where there is one way to carry out civil trials, and then many special kind of procedure, but no different tracks depending on the value of the claim. So this is for sure something that made the internalization of the ESCP regulation particularly slow in Italy. But we should also consider, and still this is in parallel to what Francesca said, that even for the ESCP regulation, the Italian government preferred to do absolutely nothing. So the regulation was there, it was immediately applicable, and the Italian legislature and government decided not to adopt any kind of, guideline or legislation or guide that could have helped, either englobing the regulation inside the civil procedural code, or anyway coordinating it, implementing it within the body of Italian civil procedure. And that would have helped, of course, Italian lawyers and courts to solve problems of conflict and doubts arising from the application of the ESCP regulation, but would have also helped making the ESCP regulation visible. Because actually, one of the things in Italy is that very few people know about the regulation. And paradoxically, the fact that the regulation has not been implemented throughout local legislation makes it quite hidden. It's not like in countries, and many in Europe did that inserted some new rules inside the Code of Civil Procedure, where of course that means that any law student will be forced to realize that the regulation is there. Well, this is not the case in Italy. However, now going to the bright side, this decision, to remain passive by the Italian government and legislation have also some positive consequences. One is that it's especially for foreign claimants, that if you are thinking of applying for an ESCP regulation in Italy, but the same would apply for the EOP regulation, well, you don't have to care about national rules of implementation, because all you need to know that matters in Italy is in the regulation. We did absolutely nothing. There are no implementing rules or guidelines. So that makes it very easy for foreign claimants to come to Italy and to use the procedure that they want to. That is one thing. And the other good news is that since Italian case law on ESCP is very limited, again, foreign claimants do not have to worry to check Italian case law, because actually there is almost none, very, very, very limited. And moreover, it's very hard to find. So even Italian judges will not be able to find that. And well, if we want to see some positive side of the picture, this might be one of them. And the third one is that the third positive and bright side is that there are projects such as the one that we are carrying out right now. And as Francesca said, the rate of participation and the rate of curiosity, I would say, that participants in our seminar demonstrated showed that initiatives such as these ones might truly help making the regulation exist before the eyes of Italian lawyers, and maybe also become a procedural reality. So thank you very much once again. Marius, the floor is back to you.